Hello, everyone. Today, we're going to break down Chapter 9 of India's Digital Personal Data Protection Act. Now, I know it's called miscellaneous, which sounds kind of boring, right? But trust me, this chapter is the real engine room. It's what gives the entire law its horsepower and gets it on the road. All right, before we dive in, just a quick heads up. Please take a moment to read our standard disclaimer. This explainer is just for educational purposes. So here's what we've got on tap. We'll start by looking at why this chapter is the Act's engine room. Then we'll get into the government's powers, see how this law stacks up against others, figure out how it stays current, and finally, wrap up with why all this fine print really matters. Let's get right into it. First up, let's really get to grips with why this chapter is the operational heart of the whole Act. It might sound like a catch-all section, but it's where the law gets its practical strength. Well, the miscellaneous chapter is basically where the rubber meets the road. It's where theory becomes reality, it sets up the whole framework for enforcement, it allows the law to change with the times, and it makes it clear who's in charge. You can think of it as the instruction manual that turns lofty data protection ideas into real-world action. Okay, so how does the law actually get its muscle? Let's take a look at the specific powers that give the Act its teeth, and also the protections put in place for the people who have to enforce it. Check this out. This is Section 35, and it provides what's known as good faith protection. What that means is officials who are enforcing this act can do their jobs without worrying about being hit with frivolous lawsuits for just, doing what they're supposed to do. It lets them be decisive. And then you've got Section 36. This gives the government the power to ask for any information it needs from the Data Protection Board or any data fiduciary. That's basically any company that handles your personal data. It's a really important tool for oversight, making sure everybody's playing by the rules. And here's where things get really serious. Section 37 is the government's ultimate enforcement power. So if a company keeps breaking the law, we're talking getting penalized 2 or more times, the board can actually recommend blocking public access to their platform, and then the government can step in and order it to be blocked. It's a huge deal. So a big question with any new law is, where does it fit in with all the other laws that are already out there? This part is absolutely crucial for understanding just how much authority the DPDP Act really has. Section 38 makes the legal pecking order crystal clear. It basically says if there's any conflict or disagreement with another law, the DPDP Act wins. Simple as that. This establishes it as the top authority on digital personal data protection in India. And Section 39 adds another layer of strength. It says that regular civil courts can't touch cases that are under the Data Protection Board's jurisdiction. This keeps data protection issues with the experts, which should make the whole process a lot smoother and faster. Let's be real, technology is evolving at a crazy pace. So how does a law from 2023 stay relevant in 2025 or 2030? Well, it actually has some pretty clever flexibility built right in. Section 40 is really the key to the Act's long-term survival. It gives the government the power to create detailed, specific rules for how the law actually works in practice, so they can define exactly how a company reports a data breach or how consent for kids' data should work. This means the law can adapt to new tech without needing a complete rewrite every few years. Now, what about the fines? Under Section 42, the government can also update the financial penalties. This is super important to make sure the punishments remain a real deterrent over time. But, and this is a big but, there's a safeguard. They can't just increase a penalty to whatever they want. It can't be more than double the original amount. And finally, there's Section 43. You can think of this as a temporary troubleshooting tool. For the first 3 years after the law starts, if any unexpected problems pop up in putting it into practice, the government can issue orders to smooth things out. It's a very practical way to ensure a successful launch for this massive new law. Okay, so we've gone through all the powers, the protections, the procedures. Let's take a step back now and look at the big picture. What does all of this actually mean for you and your data rights? Here's the most crucial point. This isn't just boring legal jargon. This chapter is the absolute backbone of the entire Act. It creates the framework that makes all those data rights we talk about actually enforceable, authoritative, and future-proof. So, what's the one thing you should take away from all this? It's that your data rights are no longer just words on a page. They are now backed by a powerful, smart, and supreme legal system that has the teeth to enforce them and the flexibility to keep up with our crazy, fast-changing digital world. Thank you for watching. Please like, share, and subscribe.